CACI personnel, including Steve Stefanovich, Daniel Johnson, or Timothy Dugan, directly mistreated them. Instead, they claimed that these CACI interrogators conspired with Army military personnel to torture or inflict CIDT on detainees in the hard site, which resulted in plaintiffs being tortured or subjected to CIDT. That's in the appendix at 7718 and 19.
But there was also activity in the United States, such as reports, supervision, et cetera, and also a cover-up.
Well,
so why do you say there's no overt acts of a conspiracy in the United States by CACI?
Well, Your Honor, in the United States, there was no activity that was conspiratorial in nature, which we believe is the appropriate question. If ATS's focus is the conspiracy and not...
What about the alleged cover-up that Judge Floyd mentioned?
Your Honor, there's no evidence in the record of a cover-up in the United States. What plaintiffs point to is the Army asked CACI to remove one interrogator from the contract, but explicitly said, if you'd like us to reconsider this, let us know, submit something to us. And that was the contracting arm of the Army, and the operational folks in the Army wanted CACI to keep the employee because he was doing important work, so CACI asked for reconsideration. That reconsideration was denied. CACI took the employee off the contract, and that was the end of it. 6 years ago, this court...
Counsel, can I, on the extraterritorial, it seems, help me with this, under the Supreme Court's Nestle and Arbitron, I think I'm saying that last one right, the cases, it seems like the court has made clear that the way we look at the extraterritorial question is the focus of the statute, here the Alien Tort Statute. And it seems like the last ruling from the district court on this point, while it referenced that a little bit, really was holding firm on the Al-Shamari 3 decision. So this case kind of went to the jury on extraterritorial analysis that seems pretty clearly outdated under the subsequent Supreme Court cases. Do you agree with, am I right that under the focus test, what we're looking for is the focus of the statute and not specifically the cause of action?
That's right, Your Honor. And we agree with Your Honor's characterization of what occurred at the district court. The district court's opinion did mention the focus test, but then said a mechanical application of the focus test to reject these claims would not be appropriate because it didn't meet the district court's view of the policy interests underlying the presumption against extraterritoriality. And so then the district court went and considered things like CACI status as a U.S. corporation, citizenship of CACI and its employees, the contract was issued in the United States. And we know from, and I think it's Arbitron, it looks like it should be Arbitron, but I think it's Arbitron, held that interests, statuses, parties, those are not relevant considerations. It's conduct. So you start by identifying the focus.
It's the focus of the statute. So a plaintiff has the authority, or subject to some other arguments, to fashion their cause of action the way they seem fit. But the extraterritorial application, you can't change our focus from what the statute is prohibiting.
That's right, Your Honor, because the focus test and the presumption against extraterritoriality at bottom are tools of statutory construction and that must be followed. And so you have to find the focus of the statute. And in our view, and it was the United States' view in the Supreme Court in Nestle, is that the statute's focus is the primary tort. Because
so that brings up another question I have that haven't seen a whole lot of indication that it's been considered. The statute provides district courts with jurisdiction for a tort involving violation of the law of nations.
Correct.
So what work, or what's the significance of tort in the statute? It seems as if we're almost saying that the violation of international law is itself a tort.
I think,
And the question is whether that is right, or whether there must be a tort, a pre-existing recognized tort that the violation of international law fits into.
I think as I read the case law, the understanding that from Sosa, the court's view of the understanding at the time of the enactment of ATS is that the tort had to be a conduct that was tortious in nature and in violation of the law of nations.
Well, let's look at it this way. Tort is obviously a wrong, physical harm to somebody for which there should be a remedy. The statute also says treaties, and we have the Geneva Convention, which clearly prohibits torture against detainees or prisoners, and certainly that is a modifier of the international norms, that torture is recognized internationally as something that is not acceptable in a civilized society.
Oh, we agree with that wholeheartedly, Your Honor.
And so why, if torture, which is a form of assault and battery, which is a tort, why isn't that satisfied?
Your Honor, we do not quarrel at all with the principle that torture is a violation of the law of nations. We don't quarrel with that at all. But SOSA is a two-step process. The first step is the proposed cause of action a clearly defined and universally recognized violation of the law of nations? We don't dispute that at all.
And what is it? Is it torture?
Well, we think torture qualifies for sure.
Okay, all right.
But then,
Well,
as SOSA makes clear, there's I'm
Before
sorry.
you get to the second prong, I'm sorry to
No, you're
interrupt you there, but Judge Floyd mentioned that torture could be battery. I think that's a fair comment. I'm just trying structurally to see how we do this. Do we look at the the alleged violation of international norms or treaties and say, well, if it kind of, if it seems analogous to a tort, that's enough? Or do we have to identify a tort and show the elements of the tort? I mean, for example, if it was battery, there are elements of battery, and torture might well satisfy those. But do we have to formalistically identify the tort, or do we just have to determine that the alleged violations of norms themselves are tortious, I guess, in some sort of, metaphysical sense?
I think the latter, Your Honor. Clearly, I think all torture is a battery, but not all batteries are torture. Plaintiffs did have common law battery claims and the like, and those were all dismissed with prejudice. So we really are dealing with the second prong of the SOSA
What's
judgment
the
test.
authority that says, when you said the latter, you think SOSA says that?
I think SOSA is the best explanation of it, Your Honor.
Okay, you can move on, I'll look at that.
And the second half of the test, though, is this basically the standard Bivens test. Is there any sound reason, once we've found that we've got a recognized violation of law of nations, are there reasons that we ought to let Congress lead the way in deciding and defining any cause of action?
But Bivens is, well, let me back up. Back to the battery first. We argued, the argument is there's a conspiracy in this case. It has to have overt acts. Does it matter that, for example, the causes of action like battery, et cetera, were dismissed as it relates to the evaluation of a conspiracy and its overt acts? Cannot a battery still be the overt act in support, that supports the conspiracy claim?
Well, Your Honor, I think conduct that would qualify as torture would certainly qualify as a battery. And what the fact that the common law counts were dismissed, I don't think changes the court's analysis, but there's at least 4 reasons why under the Nestle, Goldie, Bivens analysis, this court should defer to Congress. And there's
Well, isn't Bivens a court-created situation?
It is, Your Honor.
So but if that's true, in this case, there is a statute, not a court-created, a statute overriding the whole thing, which has to be filled in, obviously, by Congress or by the courts. But where there is a significant violation of international norms, why is it that the court can't touch that?
Well, for the same reason that the court couldn't touch the claims against Nestle and Cargill. I mean, everyone would agree that forced child labor is abhorrent, is a violation of the law of nations. Everyone would agree with that. But it's a question of, as Your Honor said, a substantive cause of action has got to be filled in by either Congress or the courts, and the Supreme Court's been pretty clear about which of those it ought to be. It ought to be Congress. Congress has created a statutory cause of action for torture, the Torture Victims Protection Act.
And Sosa and Jensen are both ATS cases, and they say, look at this second prong, right? And if the ATS statutory existence was enough, there'd be no point in the second part of the test.
Yes, Your Honor, and I would particularly point the court to pages 264 and 265 of Jesner. The court begins by...
I said it wrong, so it's Jesner, not Jensen.
There's a lot of cases, Your Honor. The court begins at 264 by looking at Sosa and says, Sosa's consistent with our general Bivens principles, where the court has been overtly hostile to new causes of action.
And it cites Ziegler, right?
It cites what, Your Honor?
Ziegler?
It cites Ziegler, for sure. And then the next 2 paragraphs, the court talks about cases like Ziegler, where the court had established a very stringent test for judge-made causes of action. And then the next paragraph, the court reaches the question, well, do all these Bivens precedents, do they apply in the ATS context? And this is what the court said about that. The court said, neither the language of the ATS nor the precedents interpreting it support an exception to these general principles in this context. In fact, the separation of powers concerns that counsel against courts creating private rights of action apply with particular force in the context of ATS. And in Jesner, the court adopted the exact same language for the test that's being applied in Bivens, at step 2 of Bivens and step 2 of ATS. And we have wartime context. That's a reason to defer to Congress. Congress has repeatedly legislated in this area. We have the Anti-Torture Act. We have the Torture Victims Protection Act. We have the War Crimes Act. We have the Military Extraterritorial Jurisdiction Act. Congress has repeatedly legislated and not created a cause of action here. And we know from Supreme Court case law, like Goldie, like Ziegler, that when Congress has repeatedly legislated in an area, that's a particular reason for courts to stay their hand and defer to the causes of action Congress has decided to create. And the district court actually reached the opposite conclusion and said, well, Congress is legislating in this area, so that means it would be comfortable with me filling in some gaps. And Ziegler and Goldie make clear that it's actually the opposite conclusion that should be drawn. And then we have the administrative claims regime, which this court and the Supreme Court have repeatedly held, if there's an administrative claim available, which there is, the Secretary of Defense made clear that it would take and consider administrative claims of detainee abuse coming out of Abu Ghraib prison. The lesson from that is that courts should not create a cause of action, even if that administrative claim is inadequate. In Bulger, Dyer, the administrative claims process was either viewed as inadequate or unavailable to that plaintiff. And the court said, well, that's sorry, but when there's an administrative claim process available, courts should not be in the business of creating causes of action because that's Congress's job. 6 years ago, we were in Spartanburg, South Carolina, and this panel told plaintiffs exactly what they would need to show to make out a domestic application of the statute. So moving from judge causes of action to extraterritoriality. And Your Honor, Judge Quattlebaum said they needed not just theories, but evidence with JA sites of the conduct that happened in the United States. And Judge Floyd pointed out that this case rises and falls on that. And they don't have conspiratorial conduct in the United States. Nestle made clear, Nestle, the court was concerned with, is the focus of the statute the primary violation, or is it the secondary claim? And the court said, we don't need to decide, because that case was aiding and abetting, and it said, even if it's aiding and abetting, the plaintiffs lose, because nearly all the conduct, not even all, but nearly all the conduct that qualifies as aiding and abetting occurred overseas. So if the focus is conspiracy, which we submit that it's actually the primary tort, all of the conspiratorial conduct, the only conspiracy the district judge instructed the jury on, occurred in Iraq. And that would make this an extraterritorial application of the statute.
Before you sit down, will you comment on the fact that there's some John Doe defendants and what the status of those defendants are and what they do, if anything, to whether we have finality below?
Yes, Your Honor. So after the plaintiffs dismissed their claims of direct abuse by CACI, we third-partied in the United States, and John Doe's, I think, 1 to 60, and those would be soldiers who actually abused plaintiffs. The district court severed those claims. As a functional matter, well, as a practical matter, we don't really have an ability to pursue them, because the state secrets privilege is going to prevent us from learning their identities. But severed claims are treated as independent actions for purposes of finality and appealability. The leading case on that is Gaffney versus Riverboat Services of Indiana, which is 451 F3rd 424, pages 440 to 441. That's the Seventh Circuit. This court in Kraus v. Town of Monk's Corner, 848 F3rd 576, 582 Note 2. It's a 2017 decision. Cited Gaffney with approval. And we think that's right. When a claim is severed, it's treated as as if it's now a separate action for purposes of finality. If it had been separate trials, it would not. But severance and separate trials are treated differently for finality and appealability.
So that means if it's ongoing, it's a separate matter that we don't have to consider at all?
That's exactly right, Your Honor. It's not before the court. It's not part of the final judgment. As I said, as a practical matter, it's a claim that we're never going to be able to prosecute because of the state secrets privilege. But it does not affect finality or appealability of the final judgment the district court entered for this case. Thank you.
All right, thank you.
Good morning. May it please the court. Bahar Azmi for the plaintiffs. I'll be taking 14 minutes to address call the Fed court's questions in the case, and my colleague will address some evidentiary issues. Your Honor, we all agree that the Nestle focus test applies here, including the district court, who spent 20 pages analyzing the facts under the Nestle focus test. We have some disagreement about the continuing vitality of Al-Shamari 3 and the touch and concern test, because we do think those tests are related, as Roe v. Howard suggested. Yeah.
The district court did do that,
Yep.
but decided the case based on Al-Shamari 3.
Respectfully, no, Your Honor. She applied the focus test and asked this critical question: what is the focus of the ATS, which CACI has not done? And to find the focus of the ATS, Abitron suggests you look to the object of the statute's solicitude, which includes the interests it seeks to protect, the conduct it seeks to regulate, or the parties it seeks to protect. And the Supreme Court has told us what interests the ATS seeks to vindicate. It's from the Jesner opinion. It seeks to promote international harmony by providing a remedy, judicial remedy, for international law violations where otherwise the U.S. would be held responsible. That's repeated in Kiobel, and Alito and Gorsuch, in respective opinions, underscore that that is the focus. And that's the test she applied, rejecting the idea that the particular location of the tort is what matters. And I want to sort of clear some conceptual errors for Kathy before I go into the extensive, what the district court called, who sat through the trial, quote, extensive conduct in the United States that relates to the focus. The first suggestion from Kathy is that all facets of the tort have to occur inside the United States. Well, that conflates the theory of liability, which is conspiracy, with the question of extraterritoriality. We don't have to show that all the overt acts in the conspiracy happened in the United States. We just have to show that conduct relevant to the focus happened in the United States.
And opposing counsel says that all of it occurred in Iraq, that none of it occurred here. So I think you're about to list, it would be helpful if you would list.
Let me please, yes, Your Honor. I think there are two sets of factors. First is the U.S. Dominion over the relevant territory. And we call this the complete jurisdiction and control. And I want to be clear here. We do believe that you could decide that the presumption doesn't apply at the threshold, because the point of the presumption of extraterritoriality is, would you create foreign entanglements? Or as the Albitron case said, for foreign conduct, we apply foreign law. But what's critical here is there was no foreign law in existence at the time. The United States occupied Iraq. Under the CPA, displaced all Iraqi law. And under the CPA, there's more facts to this that I recommend from the Fed Court's amicus brief. The key fact is it immunized Kaki from Iraqi law and required that U.S. law apply. So as the district court concluded, that's certainly relevant to the focus, because the United States this harm would be attributed to U.S. actors and the United States if we failed to provide a remedy for this well-known tort. And then there's continental U.S. conduct, and I want to suggest that it exceeds the conclusory allegations of general corporate liability in Nestle, and shows a very tight connection. First, Kaki is incorrect. The U.S. corporate status is still relevant. It's not dispositive, that's clear, but it's still relevant to the focus because of attribution. And in this case, I would suggest that there's a beginning, middle, and an end to the set of facts that are directly connecting the U.S. conduct with the ultimate tort. Again, unlike Nestle. At the beginning, the key fact is Kaki recruited, hired, and gave security clearances to several interrogators that Kaki sent to Iraq, despite the obligation to identify resident experts and despite the obligation to supervise, including supervise to prevent mistreatment, engaged in the very conspiracy with the U.S. soldiers in this case that led to their court-martial. Kaki cites Adhikari. What's interesting about Adhikari, although it goes the other way, the number one factor Adhikari analyzes is, this is a forced trafficking case, is where did the recruitment take place? And the court said that made the tort possible. The recruitment that took place in Adhikari happened in Nepal, Jordan, and Iraq. Here, the recruitment happened domestically, and it directly caused the tort at issue. Then we have the middle set of factors, which is, again, in Nestle, the court emphasizes there was basically zero presence in Cote d'Ivoire by the U.S. company. Kaki is all over Abu Ghraib and Iraq. They have a supervisory structure on the ground that has an in-country manager and the site lead. They don't talk about Dan Provoznik in their brief. He was critical in this case. And according to that supervisory structure, he provided operational supervision, his words, over interrogators, and had daily communications with headquarters about things like hiring and firing. And in the middle also, there is this
And that was done from the United States, is that?
No, there was,
None of the supervisory efforts occurred in the United States?
There were, because there were reports back, for example.
Yeah, so that's what I'm looking for
Yes,
anyway,
yes.
is that list of conspiratorial conduct that occurred in the United States.
Yes, so for example, Richard Arant, in what the district court characterized as a smoking gun email in October, said that he was leaving because of problematic interrogations. And Amy Jensen Monahan, the program manager in Virginia, testified that they did nothing to follow up on that investigation, representing deliberate indifference. And then Dan Provoznik himself. This is about the focus and attribution. He lies not only once, but twice to the Army about Arant. The first time he tells them the reason Richard Arant left was he needed cataract surgery. And then the second time, that's in October, the second time in January, the military asks him, do you have any information that's relevant to mistreatment? Dan Provoznik says, no. Then there's, and then he's also told by Torrin Nelson, a khaki employee who testified for plaintiffs, that Provoznik was told about these abuses. So there's this connection. The problem, and then I want to get to the. Let me do the last set of facts, Judge Thacker.
Let me suggest to you, Judge Breckerman listed 10 different things to wrap it up, so you can get to the implied cause of action thing. It was, in the end, it was reports that including a desire to cover up abuse quietly, letting go a khaki interrogator who provided information to the Army CID, communications with military and in-country personnel regarding response to leaked photographs. She listed 10 things in the record that were domestic activity by khaki.
That's right, including, and then the cover-up is key, and Al-Shamari and Adhikari say cover-up is important, and it's obviously important, the focus, because if you cover up a tort, that implicates the United States, and the United States sent, the Army sent khaki a picture of DJ, one of the unqualified interrogators, the co-conspirators, in a stress position, and suggested he be terminated. Khaki minimized to say this is just the cultural preferences of Iraqis.
How about the implied cause of action?
Thank you, Your Honor. Yes. This is so fundamentally unlike a Bivens cause of action, as you observed. The problem, ATS is a federal statute that authorizes federal courts through congressional choice to imply causes of action. The problem with Bivens is there is zero congressional imprimatur whatsoever. And the Hernandez case also emphasizes the problem with a Bivens cause of action is the Fourth Amendment might provide a norm that people should follow, but there's no remedy attached, and Congress should make a remedy. The ATS reflects, quote, a congressional choice. That's SOSA, to provide causes of action. In the very case they rely on, Judge Floyd and Judge Quattlebaum, Jessner says, everyone understands that this was not a piece of, quote, legislation that was meant to sit on a shelf. It was understood that federal courts would identify causes of action, and it's sure, Jessner cites to Ziegler around sort of judicial caution, but the decision is really ultimately limited to the idea that you should not, consistent with the focus of the ATS, subject a foreign corporation, because suing them would cause discord. Here, all of the sort of factors, as Your Honor suggested, Floyd, support a cause of action. We have congressional endorsement via the Geneva Conventions, the Convention Against Torture, the Torture Victim Protection Act, which really seeks to provide the same remedy. Congress says this. We want the same torture remedy that exists for aliens, for U.S. citizens. And then we have executive conduct here through signing of the Geneva Conventions, and military law and policy, which required adherence to the Geneva Conventions, prescribed the conduct here, and court-martial the very co-conspirators in this case.
Let me make sure I understand where you're going with that. I certainly appreciate the United States official action that adopts and approves those that international treaties and conventions and things. But isn't the question whether they, it seems like you're saying because the United States has taken action that would be consistent with, or that says torture and this sort of detainee treatment is improper, illegal, whatever, that implies that there would be a cause of action that could be pursued against it.
Let me be,
And I think the way the test that Sosa talks about and the test that Jessner, I got it right, at least now, that Jessner then talks about as well is requiring an analysis of whether a cause of action would be disruptive based on other things. And so why shouldn't we view the fact that there's never been a cause of action created as evidence that despite all this action by the executive and legislative branches, there isn't one?
There is a cause of action for torture because the Supreme Court in Sosa endorsed the cause of action for torture, as have numerous courts. So that much is clear. And then at step 2, of course, we exhibit some judicial caution, but it goes back to the focus. The reason I identified the political branches' adherence to the anti-torture norm, because it goes to the focus, which is, will we create foreign entanglements if we don't provide a remedy here? That's from Jessner. And given the universal consensus about the norm of torture, failing to provide a U.S. remedy would severely implicate the United States and the focus of the ATS.
Well, you know, Justice Breyer in Sosa even said something to the effect that notwithstanding Erie, international norms keep the door ajar.
That's
He said that twice for new common law causes of action, because for 2 centuries domestic law has recognized the law of nations.
That's right. And Breyer's, keep the door ajar, Breyer's quoting the majority opinion in Sosa. And Sosa also says the ATS's unfortunate word is not meant to be stillborn. We understand that despite Erie, Congress has asked federal courts to create this cause of action rather than federal courts independently on their own, creating one. And I think that's important.
I think, I appreciate Judge Floyd's right about that. And I think the question is how the door is ajar under current law, but the way we determine whether cause of action fits in that ajar door is the 2 steps of Sosa, and now, not Jensen,
Jessner.
Jessner. See, sorry. You agree with that's the framework? I
Yes.
know okay.
Yeah, the second step. And I just think at the second step, there's no reason to exhibit caution, given the constellation of factors that are connected to the remedy, which is, connected to the focus, which is offering a remedy where the U.S. be implicated. And, just this, if I just, I'm nearly out of time. If I could just take.
You're actually out of time.
Okay. If I could just take one moment, Your Honor.
Go ahead.
This is, contrary to the suggestion that this is some kind of exotic case, this is the rare case that sits at the juncture between the presumption against extraterritoriality and the focus. So providing a remedy here wouldn't implicate the presumption against extraterritoriality because we're not conflicting with any foreign law. And avoiding a remedy here would implicate the focus because it would not provide a remedy for very serious international law violations.
Thank you.
Good morning, Your Honors. Michael Buchanan, pro bono counsel from Patterson-Belknap on behalf of the plaintiffs. And I just want to address briefly some comments that Mr. O'Connor made in his statements. Primarily, the idea that the state secrets frustrated the truth-seeking process in the district court. We believe, and the record shows, that this case was fairly litigated in the district court, and that CACI presented its defenses through unclassified Army evidence, including internal memos, the testimony of Army and CACI interrogators, and its own witnesses in the cross-examination of the plaintiffs, and they concede as much in moving for post-trial relief, claiming in their papers that the evidence they presented on, for example, the borrowed servant doctrine, their primary defense, was overwhelming, and that they should prevail on that defense. In addition, nothing—
Counsel, can I ask you a question about the state secret issue? This was a little bit surprising to me because it feels like the district court upheld the state secret in certain aspects and made trial decisions based on it. It seems kind of like an abuse of discretion sort of process, but it looks like Masri is pretty clear that both the applicability of the privilege and you know, and whether to dismiss or not, and how you handle it are questions of law. Do you agree that they're questions of law?
Partially, with regard to the assertion of the state secret privilege in El Masri and other cases relied upon by CACI, the government, with sworn statements, represented that the entire programs, the personnel and the contracts that were subject to litigation were themselves.
We'll move from the application of it. That's really not my question. It's how you deal with it, and in terms of the trial, including dismissals or not. Doesn't El Masri say that's a question of law too?
With regard to the evidentiary rulings, Your Honor, if that's what you're referring to, those are abuse of discretion standards. So there was substantial evidence available to CACI to prevent its.
But they're saying it should have been dismissed based on the
Yes.
state secrets privilege, and that is a question of law?
It's a question. Well, I think it's a question of law. In fact, Your Honor, because the question is the information that's classified so central that the party cannot present its defense or its case.
That's the test, but that's how you show it, but I'll just read the case. I'm trying,
Okay.
I mean, I'm pretty sure El Masri says that's a question of law, the decision on the test you just described.
I think from the perspective that the court is looking at this now, the question is, was CACI able to present its defense? And the answer is yes, both on the borrowed servant and on the substance. For example, nothing prevented CACI from calling its own interrogators to testify at trial, just as they did with Mr. Stefanovic, and just as the plaintiffs did with Mr. Nelson. Those witnesses were available. They could testify about what they saw and what they did in Iraq. There was no reason they could not have been called. With regard to their defense on the conspiracy theory, their theory, which we disagree with, is that a particular CACI interrogator had to be assigned to a particular plaintiff. They had the sworn testimony of all interrogators assigned to the plaintiffs in this case. They took that testimony, they all denied abuse, they presented it to the jury. So they fully and fairly presented their defenses to the jury, and the jury rejected them.
Well, that you say fully, I mean, whether this rises to the level of a constitutional violation, it might be debatable, but it was, different than in a normal trial. It was, you gotta at least recognize that the way discovery went, and they weren't allowed to get things that would normally be within the purview of discovery, and within the way the trial went, they weren't allowed to do things that normally happen during trial. Now, that seems undeniable. The question then is it enough and prejudicial enough that it violates the due process clause? That may be a high bar, and maybe they don't get there. But just to say fully, like they got everything they wanted, that seems kind of, like you're just ignoring what happened.
Not suggesting that they got everything they wanted, but they got enough to present their cases fully. And I think this case is like the Reynolds case in the Supreme Court, where the government offered a reasonable alternative to the evidence and provided them with evidence that they needed for their case. And briefly on the conspiracy point, I would point the court to a case that CACI relies upon, Oki Semiconductor. The liability for acts of co-conspirators, quote, reflects the notion that the damages wrought by the conspiracy is not to be judged by dismembering it and viewing its separate parts, but only by looking at it as a whole. So what the conspiracy theory here and conspiracy liability is a direct application of black letter law. We are holding CACI accountable for the actions of its CACI interrogators meeting with military police outside the formal interrogation process and giving them instructions to abuse detainees, plural, indiscriminately across the board. And you see that in the photos. That's exactly, they took those instructions to heart. That's exactly what they did. Widespread nudity was rampant. It was standard operating procedure within the facility, and numerous detainees suffered exactly the kinds of abuse that our clients suffered. Thank you, Your Honors.
All right, thank you.
May it please the court, Mike Shee for the government. I want to take a step back and focus on the particular claims that brought the United States here. And those are the claims in CACI's third-party complaint against the United States. Those claims, as we explained in our brief, are barred by federal sovereign immunity, and the court's contrary conclusion violated decades of precedent from the Supreme Court and from this court. On appeal, CACI doesn't merely decline to defend the district court's analysis of sovereign immunity. CACI actually agrees that the district court got it, quote, patently incorrect. So the court should affirm the dismissal of CACI's third-party claims against the United States on sovereign immunity grounds. I'm happy to answer any questions the court has on federal sovereign immunity. Otherwise, we're happy to rest on the arguments in our brief.
Do you have a position on the John Doe defendants?
Yeah, so as we point out in the first footnote to our brief, our understanding of the finality issue is the same as CACI's understanding. The claims against the John Doe defendants appear to have been completely severed, and because they were completely severed, it's basically a new case, and so there's no issue with finality as far as we can see under the Seventh Circuit decision that they point to and this court's endorsement of it in that footnote in the case that we cited there.
Thank you, counsel.
Great, thank you.
All right, thank you. We'll hear from Mr. O'Connor again.
Thank you, Your Honor. Mr. Osme, in talking about extraterritoriality, told the court that status is irrelevant. Recruiting in the United States is relevant to extraterritoriality. U.S. citizenship is relevant. All of that is directly foreclosed by Nestle and Avatron. Avatron couldn't be clearer in saying the only things that are relevant are conduct, because it's too easy to take interests, statuses, et cetera, and twist an extraterritorial claim into a domestic claim.
He went on and talked about some of the things that the district court mentioned in other U.S. activities related to reports and cover-up and things like that. What's your position on that?
And that's the other side of the coin. Nestle makes clear that general corporate activity is also not
But that's
sufficient.
not general corporate activity. That's activity related to the specific allegations here. They're saying evidence that not just general activity, but things peculiar to the mistreatment of these detainees happened in the U.S.
Well, Your Honor, I would submit that the court should look closely at the citations on which plaintiffs rely. They talk about reports. The government report, or the reports from CACI back to the United States, they're at 12171 to 12358. It's 175 pages of them. Court won't find one discussion of intelligence gathering, of detainees, of treatment of detainees. It's all administrative stuff. The errant email, which is at JA8158, that, if the court reads Mr. Errant's email, all he says is he saw a violation of the interrogation rules of engagement, which he doesn't specify, by junior enlisted soldiers. He's very clear that CACI personnel had nothing to do with it, and that he had the highest regard for all the CACI personnel with whom he'd interacted.
Well, Mr. O'Connor, since you brought up citations, there are a number of citations in your briefing that don't appear to be accurate. And one example is in your reply brief on pages 21 to 22, where you quote Hensley, and that quote doesn't exist. It's not accurate. The quote I'm talking about on pages 21 to 22 is, it says, quote, preemption is designed to further the, quote, federal interest in eliminating non-federal tort regulation of the military during wartime. But that's not an accurate quote.
Your Honor, I'd have to go back and look at Hensley.
Right,
Certainly,
and
that's what the court said. Whether the
Well,
quote is
you
right
put it in
or wrong,
quotes,
I
you put it in quotes in your reply brief, and that's not accurate. And there are a few other instances of that in your briefing. So I'm just bringing it up since you mentioned that we should look closely at citations. So we've looked closely at yours, and I think probably, unless my colleagues have more questions for you about that now, probably what's more fair to you is perhaps we'll follow up with something listing all the inaccuracies in your briefing so that you could respond.
Thank you, Your Honor.
And
And
I'll give you one more on damages. Khaki contends that it appears that courts borrowed forum damages law from ATS claims. But this is really an overstatement, which we don't borrow forum damages in assessing damages. Rather, courts imposing damages under ATS consider the following factors, not what you said, but what I just pointed out to you. So that'll be included in the follow-up too.
I appreciate that, Your Honor. I see my time has expired.
Well, do you have any more questions, or do you have any more? All right,
Thank you, Your
thank you.
Honor.
We'll come. Yes, we'll have them. You want them to come up here?
Yeah,
All right. Right here. Would counsel, we can't come down. Oh, okay. All right, you all come, we'll come down. Judge Floyd will stay here. After we greet you all, you come and greet Judge Floyd up here. How about that? And then we'll proceed to the next place. I was going to have him just.
Hey, no.
All right, that works.
You know, I haven't fallen 18 months. I fell last time.
Oh, no.
Flat on my back.
Oh, no.
I'm getting old.
Sorry, I
No,
just,
you're good. I may be crowding you.
no, this bench is. I think I'll put that over there. All right, we're ready for counsel in United States versus Robinson, whenever you all are ready.
Thank you, Judge Thacker, and may it please the court, Eric Brignac for Carlos Robinson. We are asking this court to do three things. Vacate the district court order dismissing this motion as an unauthorized second or successive motion, to hold that the motion is a first motion filed after the amended judgment, and to remand with instructions for the district court to consider the merits of the motion in the first instance. Section 404 First Step Act proceedings are different than most sentence, quote, modifications or most clerical corrections.
Counsel, could you please address the jurisdictional question first?
The mootness, Your Honor?
Yeah,
Yes.
whether we can hear this matter as a matter of Article III jurisdiction.
Yes, of course, Your Honor. So I believe the way that is framed is that if this court were to hold that the district court gave two alternative holdings, then even if it agrees with us on the first holding, it would still have to affirm it could not provide effective relief. I agree with that. So where I think it is not moot is that the district court did not issue two alternative holdings because it could not issue two alternative holdings. Once a federal court decides that it lacks jurisdiction to hear a matter, as the court did here, that ends the court's power.
So I read that in your supplemental briefs and appreciate that. It's two points I'd ask you to respond to. One is whether our kind of Article III power is really at issue here. I mean, the habeas statutes certainly govern what can be appealed. And the district court used the word jurisdiction. We've used the word jurisdiction. But the Supreme Court has said over and over late that, you know, not every time courts are using jurisdiction is it really right. They would call these flyby jurisdictional statements. And so the first question I'd ask is whether this is truly a, you know, Article III jurisdiction case in which if true, that might be an answer. If it's not, I'm not sure that's really a satisfactory answer. Let me just deal with that first, so
Okay.
you don't.
So, and Your Honor, there is a recent case from this court, and it is not in the briefing. I did discover it in my prep. Kale versus Alfonso Royals, 139 F. 4th, 329.
Okay.
And in footnote 2, this court expressly notes that there is a circuit split on the question of whether the Supreme Court's hypothetical jurisdiction issue that I'm talking about exists only for Article III, or whether it also exists for statutory jurisdiction. There is a circuit split. In the case I just cited, footnote 2, this court says that treat statutory jurisdiction, which I think this is because this is Congress's habeas statute, treat that the same as Article III jurisdiction. You know, it cites the cases that I'm citing for this purpose. So yeah, I think
And
it
is
was
that
an
a-
open question until
Is
June
that a
of this year, Your Honor.
published case?
Ma'am?
Is that a published case?
It
this
is. It is a
Kale?
published case. It was from June of this year. And I apologize, I could have done a 28J letter. I wasn't sure the extent to which.
And so-
I always hate those late 28Js. I know the court can sometimes
Better
have
late
problems.
than never.
But better late than never.
So, as Ms. Hoffman, did you give her a copy of this case before argument?
No, Your
So
Honor.
she's
and
hearing about it for the first time as
She
well?
is, and I'm sorry, and of course, if this court wants any sort of supplemental briefing on that question of statutory versus Article III jurisdiction, very happy,
Yeah, I
of course,
think that would only be fair.
Of course, Your Honor.
So, let's assume, so two things. I mean, would you agree, if we have not, I'm not doubting you, by the way, in talking
Yeah.
about that case. I'm sure that's what it says. If this was considered a claims processing rule rather than a jurisdictional rule, would you agree that what you're talking about is not correct?
I think so, Your Honor, and the district court believes, I would say no, because the district court believed that it lacked jurisdiction, as it said. I don't think that it was equivocating on that point. I actually, the entirety of my brief is that the district court was wrong.
Right.
But it believed it lacked jurisdiction. And when a court believes it lacks jurisdiction, it certainly can continue to opine on the case, can give aside thoughts. Certainly this court does that all the time. You know, this issue is not before us, but we express skepticism, et cetera, et cetera. But what cannot happen under Article III is for a federal court to believe, correctly or erroneously, that it lacks jurisdiction, and then to issue any sort of legally binding holding after that point. And so I would, Your Honor, say it doesn't defeat my claim, because even if the court turns out you did have jurisdiction that was just claims processing, and so, you know, that's, I think, where we are. Maybe I also cite probably the closest case we have cited, the Moore versus Maricopa County out of the Ninth Circuit. You know, that was one where I think.
We have a case, counsel, called, and this is just what I did, kind of getting ready for this, called Pappas versus Travelers Insurance, and it's a removal case, and the district court says there's no subject matter jurisdiction because number one, it's not a federal question, and number two, all counsel didn't join. And we consider both those arguments. It just seems kind of odd to me that a district court, that we wouldn't be able to consider those issues when the district court's given alternative holdings? Even those are probably good, those do go to jurisdiction.
Well, I think, Your Honor, that this court, the district courts, the government would call it an alternative holding. I would call it opining without legal effect. There are two reasons that I think this court cannot affirm on those grounds. You know, beyond my argument that it has no legal effect. They're fact-bound issues. They get to equitable tolling. They get to the merits of the case. The equitable tolling will involve discretion. So prudentially, the district court is the proper place to adjudicate those in the first instance. And then secondly, this court denied a certificate of appealability on those questions. So it puts us in a very weird procedural posture, I'll grant you. But to affirm the alternative holding, you know, this court would have to basically itself opine on something where it denied a certificate of appealability. So
Fair enough.
if-
That's a fair point. I guess my question is, rather than affirm on it, we ruled on it in terms of whether there's a substantial issue. So
Yes.
is that affirming in the truest sense? Maybe not technically, but we're basically saying there's no basis for us to grant a certificate on it.
And I think what really needs to happen is not to say, well, I think if this court affirms on those grounds, it's necessarily saying that that was a legally binding district court holding, which I think it did not have the power to issue. And I mean, I do think it's hard to affirm something without reaching the merits. As a practical matter, Mr. Robinson has a very steep climb if this court sends it back. The district court put its thoughts on the record. But a steep climb and unlikelihood of success is not Article III mootness. And I would point out that he has not had a chance to address equitable tolling as he had the right to, and 16 months is a long time, but COVID was a pretty extraordinary situation. None of this is in the record, but he has opined to me that he definitely has evidence to bring to the district court when, you know, given the opportunity to do so. And that is the court to address it in the first instance. Of course, to even get there, we need to win the merits of the issue on which this court did grant a certificate of appealability. And the First Step Act itself, you know, orders the district court, or allows, the district court to, quote, impose a reduced sentence. Not to correct a sentence, not to modify a sentence, not even to reduce a sentence, to impose a reduced sentence. And Concepcion from the Supreme Court leans into that language. When it's discussing the sentence modification proceedings, it's discussing sentences that were vacated on appeal. It expressly says the only two limitations that a court has are if it cannot, you know, it can't give a defendant a second bite at the apple, and it doesn't need to do anything. It cites Rita and Kimbrough when discussing the limits on the district court's jurisdiction. Those, as this court well knows, are direct appeal cases. So Section 404 proceedings are different. Congress gave the courts wide, unfettered discretion. And I think where the other two circuits, I will also acknowledge that if this court were to agree with us on this point, it would be creating a split with the 3rd and the 11th. You know, Edwards itself from the Third Circuit drops a footnote saying that, you know, Concepcion puts our holding in some tension. We're still going to go with the 11th Circuit in Telsey, but it even acknowledges that this is a close case. And Telsey relies heavily on Dillon, which was not a First Step Act case. It was a 3582C2 reduction, which is very different and much more limited than the First Step Act. And so it relies heavily on Dillon. Actually, in Concepcion, the dissent cites Dillon to say, here's why the majority got it wrong. So the First Step Act is very different than a guidelines-driven sentence reduction. The other thing that Telsey does in the 11th Circuit, it relies on its own opinion in Stevens, which says that the 3553A factors do not apply in First Step Act proceedings. I think the Supreme Court overruled that in Concepcion, and actually the government's brief in this case on 19 acknowledges that 3553A factors apply. United States versus Richardson from this court says the sentencing package doctrine applies to Section 404 proceedings. United States versus Reed, which abrogated Collington, talks about that courts must consider changes in the law and all frivolous arguments raised by the parties. The Swain case from this court says that this court reviews Section 404 reductions for procedural and substantive reasonableness. These are, Your Honor, effectively new judgments. They're not clarifications, they're not clerical corrections, they're not modifications. They're the court doing what Congress instructed the court to do, which is to, quote, impose a reduced sentence. So for those reasons, we would say that the district court erred in saying that it was a second and successive motion, and that it lacked jurisdiction to consider it for that reason. I'm certainly happy to answer any other questions the court has. Otherwise, I'll see you in rebuttal. Thank you.
Thank you.
Good morning, Your Honors. Andrea Hoffman on behalf of the United States. Congress did not instruct district courts to impose a new sentence. Congress instructed district courts that they could impose a new sentence, and that breadth of discretion is important. No sentencing modification reduction statute in our system has ever been treated as a new judgment for the purposes of 2255, and the same is true here. Admittedly, the First Step Act did a variety of significant changes to the statutory construction of criminal process. When Congress wanted to
And
change...
could you talk about the application of the Supreme Court's decision in Magwood to your argument that this isn't a new judgment?
Yes, Your Honor. The Supreme Court in Magwood said that it was a 2254 circumstance as opposed to a 2255, but said that it is indisputable that it requires an invalidation of the judgment underneath, that the heart of what's happening we'll stay with 2255 context given the similarity of how they're handled, but the heart of what's happening in a 2255 context is that the defense counsel is, as he did today, asking the court to vacate the underlying proceeding, send it back for remand to be dealt with again. Typically that is because there's something fundamentally wrong with the underlying proceeding that has been found in the collateral review process. That's not what's happening under the First Step Act. Under the First Step Act, both Telsey and Edwards describe it as an act of legislative grace, which is a great term, frankly, because what Congress did was look back and decide that it wanted to alter something that had existed, but not impose it upon the system. It gave discretion to the district courts. It's recognizing that the first FSA, Fair Sentencing Act decision in 2010, I believe, set parameters that affected the crack coke guideline issues, but didn't apply retroactively. There was this whole bizarre phenomenon of circumstances when it applied and when it didn't. And so it's making that process now able to be retroactive in a way that had not been before. It did not order it to. It did not force it to. It required district courts to examine whether it's the crack guidelines or any other
And it
provision.
doesn't make the prior judgment invalid, as was the case in Magwood.
It absolutely does not, Your Honor, because it's not fundamentally wrong underneath. It's a correct application of the law that's now the court has the discretion to choose to view in a different parameter.
But before we get to that, before we would get to that analysis, we would need to address the mootness argument. Can you
We would, Your
respond to
Honor,
that?
and I would lean into the argument that this is a statutory jurisdictional question and that the district court can create alternative rulings as it did, as this court does all the time, for example. The system is allowing that sort of process. And so if the district court were incorrect and this court were to find it was a new judgment, then his alternative rulings would stand. He thoroughly dealt with the timeliness issue. He thoroughly dealt with multiple prongs of the merits issue. Even if we set aside the timeliness issue and don't consider whether this particular pleading was timely filed 14 months after the judgment came down, The court addressed the underlying merits of this pleading on multiple fronts. Mr. Robinson has a prior 924C conviction in an unrelated count, so even if one wanted to look at the stacking provisions of the First Step Act as being something that they would reconsider, the court did, and it would be the same. The court also then considered within the same conviction in this case, he had 2 841 convictions and 2 924C convictions, and that those both would stand appropriately as it would have been applied at the time that he was sentenced as stackable offenses. So the court thoroughly addressed the merits of this issue, and given the fact that it had under the statutory claims processing analysis an ability to create alternative holdings, this issue as Judge Quattlebaum said, there are not certificate of appealability issues issued with respect to the timeliness. And
that's critical, isn't it? Because otherwise an alternative basis could be wrong, and it wouldn't necessarily be moot if we have not commented on it in some way. And I'll say it feels a bit odd for our comment to be the denial of a certificate of ability rather than an affirmation. But, in this context, in the habeas context, those aren't the same necessarily, but the only way you get to bring it to us is if, there's a proper basis for a certificate.
Absolutely, Your Honor. It's the equivalent of saying the district court's opinion stands firm. Whether they were 100% correct or not is not what the certificate of appealability is saying. Frankly, it's not what any opinion is necessarily saying. It's recognizing that there's no basis at your threshold level for re-examining that decision.
What about the argument he makes, though, that imagine this was, imagine the district court said there's no injury in fact, but even if there's an injury in fact, there's no redressability. So we're in like plainly Article 3 land, not statutory stuff. If that had been the way it was done, I mean, does the alternative, and assume it's alternative, does the alternative Article 3 ground somehow not count, that we can't take a look at it?
Your Honor, if a court gets the threshold question wrong, but went on to consider, and this court didn't say, in case I'm wrong about this, let's address. But if you had, for example, you've made it very clear that the court, I believe I'm correct, but I'm going to consider the possibility that I'm incorrect and address the breadth of the issues that are before me. It would seem to me appropriate for the court to then consider those issues. And this court effectively did that, because this court's seen this district court, not the court before me. The district court in this case has seen this case multiple times. As you referenced the prior case, they'd been here 6 times. Mr. Robinson's been before this district court many times. And so they knew the breadth of what, this is I believe it's the 5th 2255 proceeding that's been filed by Mr. Robinson. All of the preceding ones, or many of the preceding ones, not all, were completed with a decision on successive and secondary, not merits-based or not timeliness issues. In this context, the court addressed it all. It understood, even if I'm wrong, I want to make sure that this court has an opportunity to have the breadth of my analysis of the facts that are before me and thoroughly address them all. So I do think it's appropriate for the court to consider it in either case. I do think that it's important that there's no circumstance when any sentencing reduction motion has been treated as a new judgment in this court or frankly in any other court. And part of that is because it is a bedrock principle of the analysis of how we look at affecting final judgments and when we affect them. And the courts have long held that approach is narrow. It's narrow in sentencing reduction proceedings, it's narrow, extraordinarily narrow in 2255
It
context.
seems like the cases where that's happened, the Magwood case that Judge Thacker talked about and our Gray case, both involved determinations that there was something wrong with the original judgment, number one, and then both involved a full resentencing, to deal with that error. And a difference, it may, your colleague may say this difference is not enough to change things, but it seems pretty clear that that's different than we have here. We don't have a plenary resentencing by law, and we don't have a determination that the original judgment was wrong. So we'd have to deviate from the cases where there has been a declaration of a new judgment, and we'd have to deviate from two of our sister circuits, which we can do. I mean, we got no precedent binding us on this. But am I right about the difference in Magwood and Gray?
Your Honor, you have said it perfectly, and as well as I could hope to say it. I would add on to that when you look at 3582B, that statute specifically tells this court and all courts that a judgment is final for all purposes other than the sentencing reduction provision that was authorized under, in this case, 3582C1. And this court has gone on to use that provision in Santos to say they're final for the purposes of 2255. So when you take all of the factors that the court just so amply elucidated, and you add in 3582B and this court's decision in Santos, there's no question that this is not a new judgment for the purposes of the standard for 2255, a second or successive, and the requirement of permission before it can be brought. And there's no case that gainsays against that. If the court has no further questions, I will rest on the briefs and ask that you either dismiss it as moot or deny it the determination that it is a new judgment and affirm the district court. Thank you.
Thanks.
Thank you. Your Honors, I think even under the valid-invalid framing, one thing the government correctly points out is in Magwood, it was an invalidated judgment. In Gray, it was an invalidated judgment. And I can't point to a bunch of non-invalidated cases. And the reason for that is that the First Step Act is a very different statute. I mean, we look at Collington, Concepcion, Richardson, Reed, Swain. I can't remember them all, but the First Step Act is...
But it's also not a plenary rehearing, a resentencing, that the defendant doesn't even have to be present.
No, he doesn't have to be there, and the court cannot go up. But I mean, here's the difference, Your Honor. In the First Step Act, Mr. Robinson's original statute of conviction was 21 U.S.C. 841 B1A. It changed the statute of his conviction. He is now convicted under B1B. So the statute of conviction has changed. And the district court, upon imposing sentence or imposing a reduced sentence, had to look at the 35-3A factors, had to consider all of his arguments. This court reviews it for full procedural and substantive reasonableness. So, no.
What counsel do we, I don't mean to cut you off. Finish your answer, I'm sorry.
I would rather answer your question, Your Honor, please.
I want you to get Judge Thacker's things. Judge Thacker asked that question.
No. The only time I'm doing well up here is when I'm answering your questions, so please.
I'm sorry, I didn't mean, but the...
I think you answered my question.
Okay,
So you go
thank
ahead.
Your Honor.
The points you're making about the First Step Act, I appreciate, but should we consider in conjunction with that the law as it relates to habeas claims, which are very clear about emphasizing the importance of finality. So it seems like, almost like a major question sort of issue, that you're suggesting this major change in habeas law that is not ever specified. So in addition to these other arguments, it just seems like the focus is narrow. First Step Act technically does this, this, and this. Technically, it's a new judgment, and it's going to have this effect on habeas claims that by statute and by case law are just, soaked in the importance of finality, and that we're doing that without clear direction.
Yes, and thank you. I think I appreciate Your Honor's question, and I would say the reason that this seems like a major sea change, and it all does have to rely on Congress having undercut finality with Section 404 of the First Step Act. I'm not here, this isn't Mr. Robinson having come in and had a motion for reconsideration or something that's been around for a long time. I think that the amount of litigation around that statute and the fact that that statute literally changed the statute under which he was convicted makes Section 404, a different in kind than pretty much anything else that's been around, and courts have commented on that. And that's why I think even under the valid-invalid framing, a statute that changes the statute under which my client was convicted, where he had a full 3553A resentencing, and the point of which was Congress trying to say this entire racially driven improper crack sentencing scheme was invalid, is enough to meet the Magwood test, the Gray test, and whatever other test. And so we would ask this court to vacate the district court's order and let it consider the merits of Mr. Robinson's motion. Thank you.
All right, thank you. And Mr. Brignac, would you file a 28J letter about that case you talked about, Kale,
Yes.
by the end of the day today, and then Ms. Hoffman can reply by the end of the week in connection with that Kale case that you
Of course, Your
mentioned?
Honor. It'll be a very short letter. I think
That's
it's
what
pretty
that's
much
why
on
I figure you can do it by the end of the day today. And thank you, Mr. Brignac, we know that you're court appointed, and we appreciate your work on behalf of Mr. Robinson and the work that you do every day and do quite zealously. We also very much appreciate your work, Ms. Hoffman, and Judge Quattlebaum and I will come down and greet counsel, and if counsel will come up and greet Judge Floyd after that, and then we will take a brief recess before our last two cases.
This honorable court will take a brief recess.
Ms. Hoffman, glad to have you here. Thank you so very much. I appreciate it. I love pocket watches.
I didn't see this pocket watch. So when I proposed to my wife, she said, women always get a ring and never get a present. We were in the French Quarter in New Orleans, went to an antique shop. This is my engagement present.
Hey, I got a
Slash good luck charm.
story better than that. When I got married, the second time, I inherited
Yeah, of course. You're fine.
Clinchfield Coal Company versus Mullins. Ms. Prince?
May it please the court, my name is Kendra Prince, here for the petitioner, Clinchfield Coal Company. Your Honors, this case turns on a simple but critical safeguard found in the Black Lung Regulations. Section 718-105D specifically requires that deathbed arterial blood gas studies, and I'll refer to those as ABGs further on from now, may only be credited if a physician establishes that they were produced by a chronic pulmonary condition. The language found at 105D reflects the DOL's recognition that terminal blood gas studies often reflect acute illness. The DOL specifically addressed this in the Federal Register. The DOL specifically stated that the produced requirement in the regulation was necessary because, quote, the minor's qualifying test results during a terminal hospitalization may be related to an acute non-pulmonary condition rather than a chronic pulmonary impairment. It is clear from the regulatory intent, it's clear that the DOL's intent was to require proof that deathbed arterial blood gas studies were caused by that chronic pulmonary condition and not the acute circumstances that ended in the minor's life.
Well, let me ask you this. I don't know, without commenting how this case is gonna come out, but for posterity's sake in future cases, do you want something like a doctor says, I have reviewed this report of the blood gas test, and I find to a reasonable degree of medical certainty it was the cause of his death? Is that sufficient?
Not so much as the cause of death, but it is the cause of the ABB.
I
Okay.
think the language Judge Floyd is focusing on is to a medical degree of medical certainty.
Yes, Your Honor, and we would request,
Well- Go ahead.
it would be the employer's position that the physician's report, to a reasonable degree of medical certainty, would have to establish that those specific test results were produced by a chronic
Well,
impairment.
the DOL itself used the term medically linked in the you cite to the DOL's responses in its notice of rulemaking in your brief, and the DOL itself states reliance on ABGs should be predicated on an additional showing that the qualifying or abnormal test results can be, quote, medically linked to chronic lung disease. And you don't like the term medically linked, but that's what they use. That's what DOL uses.
It is, Your Honor, in that regulatory history. However, it's important to note what the what the regulation itself actually states. The regulation itself does not state medically linked to a chronic pulmonary condition. The regulation states produced. And Your Honor, it's employer's position that link and produce are two very different terms. Link, it only requires a basic correlation, while produce requires that causal connection.
Well, counsel, can I interrupt you there? Because the ALJ said linked. Dr. Perper never, those weren't his words, those were the ALJ's words, I think. The board then, in reviewing that, said, kind of went away, didn't mention linked, and they said the statement from Dr. Perper allowed it to say that the chronic lung disease produced the studies. So it seems like the board's decision kind of at least corrects the argument you have about linkage versus produced by. I think you have another argument that says even though they used the right language, they say the substantial evidence that supports it doesn't do so at all. So my question is, are you focused on the ALJ's link language, given what the board says, or is your argument really that there's no substantial evidence at all in Perper's report that the pneumoconiosis caused those blood studies?
Your Honor, I think it's twofold. I think, the first issue is that while the board is tasked with reviewing the ALJ's language, it can't step into the shoes and say, well, this isn't what the ALJ means. You know, we have to rely on what the ALJ specifically stated. And the ALJ specifically stated, well, Dr. Perper's reports allegedly linked those blood gas studies to the chronic condition. Now, on the twofold is the substantial evidence. Employer would argue that substantial evidence does not support the ALJ's or the board's decision and orders in this case. Substantial evidence requires more than a reasonable mind. You know, generally, a reasonable mind can't be based on opinions that are silent or ambiguous as to Section 105D. You know, you can't establish, a report can't establish specifically that those arterial blood gas studies were produced by that chronic pulmonary condition if it doesn't state anything about that specific issue. And in this case, Dr. Perper's report was silent. Dr. Perper report, he acknowledged the arterial blood gas studies. He then noted that those specific arterial blood gas studies that was taken during a hospitalization and where the minor obtained or was diagnosed with acute pneumonia and acute respiratory distress syndromes.
Is this the part of the argument in your brief that Dr. Perper's report was not well-reasoned and well-documented?
That is correct, Your
Well,
Honor.
did you raise this before the board?
That Dr. Perper's report was insufficient?
It was not well-reasoned and well-documented.
Your Honor, we did raise this in front of the board, yes.
When you argued what? That it wasn't sufficient?
That when it wasn't sufficient. We have argued consistently from the ALJ up that Dr. Perper's report fails to meet the requirements of Section 718-105D.
Okay, that's fails to meet the requirements. How? First, because it uses the wrong word, and second, because it's not well-reasoned and well-documented?
That is correct, Your Honor.
And so, and both of those specific arguments you made before the board?
We believe so, Your Honor, yes.
Is one of your, switching gears a little bit, the regulation that you focus on says, test results accompanied by a report, or something to that effect? Is that, you know what I'm talking about?
No, Your Honor.
Okay, I'm sorry. So in 718-105D, it says, if one or more blood gas studies producing results which meet the appropriate table in Appendix C is administered during hospitalization which ends in the minor's death, then any such study must be accompanied by a physician's report establishing that the test results were produced by. And you focused on the produced by part. Do you? I'm actually curious about the accompanied, a physician's report accompanied by the study accompanied by a report. Dr. Perfer issued his report, years after a kind of litigation report, and I'm trying to figure out if you have challenged that at all. That accompanied by isn't something that can be a subsequent litigation report. It's got to be something that is done, contemporaneously with the study. That's not have you raised that issue?
Your Honor, employer has not raised that issue.
Okay. All right, thank you.
Dr. Perper's opinion, at most, links these arterial blood gas studies to excuse me one second. They link these terminal blood gas studies to hypoxemia. He opined that the minor had a chronic pulmonary condition, specifically pneumoconiosis and COPD, but he never linked or found that those arterial blood gas...
Yeah, because you're using the word linked now. I thought you said that wasn't appropriate.
Well, I'm saying that that's what the ALJ improperly did, Your Honor. That the ALJ improperly found, excuse me, I misspoke, improperly linked or mischaracterized Dr. Perper's opinion in linking those deathbed arterial blood gas studies to the chronic pulmonary condition. Simple generalized statements found in Dr. Perper's report about progressive disease simply does not meet the regulations. You know, to have a chronic pulmonary condition, a minor can have a chronic pulmonary condition, and the minor can have terminally disabling arterial blood gas studies. But those two may be linked, but there has to be a physician's report that establishes specifically that though that chronic pulmonary condition caused those terminal values seen in the ABG results. The two existing is simply not enough, and you have to have that physician's report that establishes that. And in addition, Your Honors, we have.
I don't know anything about this blood gas study, but the numbers are what they are. How does he go about saying that number does what you want it to do as opposed to it does something else? I mean, it's a set of numbers, isn't it?
It is a set of numbers, but it's claimant's burden, Your Honor. Claimant has to submit that physician's report, and the expert, as a physician, would review those values, review the other medical records, and come to a determination that those specific arterial blood gas studies were produced by the chronic pulmonary issue and not the acute circumstances of hospitalization.
And that would be, as I understand the regulations, counsel, there are blood gas studies and then there are deathbed blood gas studies.
That is correct, Your Honor.
So this is a requirement that's specific to so-called deathbed studies because of the peculiar issues that arise for those studies from a timing standpoint. Is that right?
That is correct, Your Honor. The Section 718-105D is extremely specific. It only applies when the minor has entered into hospitalization, that hospitalization ends in the minor's ultimate death, and during that hospitalization, arterial blood gas studies were taken.
And related to that, as I understand it, we're talking about the total disability finding, and the regulation or the statute, I'm sorry if I have it wrong, lists 4 ways that can be done. I can't remember them all. One's, I think some pulmonary studies, one's this, there's a third kind, and then there's the fourth kind of a overall review of the medical records, right?
That is correct, Your
And
Honor.
if you're in the fourth category, you could talk about blood gas studies more generally in a way that doesn't necessarily, hit the subsection 2 part. But if you look at the procedural history of this case, neither the first ALJ or the second ALJ, the focus really isn't in that subparagraph 4 section. We're in the subparagraph 2 section where you're tying total disability to these studies.
That is correct, Your Honor.
Okay. And it looks like Purford doesn't, Purford has, I think, 6 medical, legal questions he asked, and none of them deal with this regulation. Is that correct?
That is correct, Your Honor. Dr. Purper's opinion, specifically when discussing total disability, notes that, one second. He notes the treatment records in general, and that's on page JA 625. But when discussing those treatment records and finding the minor totally disabled, he does not specifically mention those arterial blood gas studies. He notes bilateral pneumonia and that acute respiratory distress syndrome. But again, and importantly in this case, is that Section 7105D specifically was put into this regulation to ensure that this acute illness was not mistaken for evidence of a chronic disabling pulmonary condition. Thank you, Your Honors.
Thank you. All right, Mr. Alston.
Good morning, Your Honors. May it please the court. I'm Brad Austin. I'm here today representing the widow in this case, Miss Geraldine Mullins. Judge Quattlebaum, if you don't mind, I'd like to go straight to what you were saying at the end. And the reason I want to do that is I can tell from the questions that your honors have asked, that you've got a great understanding of where we are in this case. So I intended to kind of go through the presumption and all that, but I think you've got that. You stated that none of Dr. Perper's answers to those questions specifically stated that the arterial blood gas studies in this case established total disability. But the thing is, the ALJ, as the trier of fact, is supposed to weigh the evidence and draw his or her own inferences therefrom. And when you look at Dr. Perper's 47-page single-space medical opinion, and the fact that, you know, Dr. Perper reviewed an incredible amount of medical records. I mean, I don't envy a physician in this position.
He probably got paid.
No comment. But Dr. Perper, I mean, Judge, he reviewed records from Dr. Smitty, Grundy Internal Medicine, Dr. Sutherland, Dr. Nazarene, Dr. Patel, Tri-State Clinic, Buchanan General, Clinch Valley Medical Center.
Right, so what part of that 47 pages would you point us to as best making the connection between total disability and the blood gas studies?
Judge, I don't think there's one sentence that I can say, look, this is the best sentence that absolutely points you there, but I'll give you several different sentences that I believe support what I just said, was which the ALJ read this incredibly detailed opinion and drew an inference that it was plain as day that Dr. Perper believed that these arterial blood gas studies that were taken during the terminal hospitalization were caused by a chronic condition. So with all these statements together, I think that's the inference that the ALJ draws. He states, and this is on Dr.
Identify where you are so we can look at it.
Absolutely, Your Honor. So I think the meat of Dr. Perper's statements are at Joint Appendix 614, 615, and we've also got 614 through 16 would be the pages that I want to reference. So he stated, Dr. Perper, that the treatment records first show symptomatic manifestations of chronic lung disease, which are shortness of breath, cough, shortness of breath on mild exertion, mucus expectoration, and he specifically stated that these started around the year 1998. So he'd go on to review 16 more years of records. So that's number one. Number two, he states specifically that these symptoms continued to progress and worsen, and they were accompanied by worsening radiologic finding and studies in the record. In other words, his clinical coworkers' pneumoconiosis continued to worsen over the 16 years that he reviewed the treatment records. That's number two. Number three, these were accompanied by objective tests in the record from all of these various hospitalizations. Those include respiratory function reductions.
Where are you now?
I think I'm at 615 at this point. It switched over from 14 to 15, Your Honor. These were accompanied by respiratory function reductions, decreased diffusion reductions, which is, DLCO as part of pulmonary function tests, decreasing gases, hypoxemia, poor quality of life at the end, and ultimately death. And then he stated that in these treatment records, we can clearly see coworkers' pneumoconiosis diagnosed throughout, both clinical and legal. We can clearly see COPD, which of course the first word of COPD is chronic obstructive pulmonary disease, clearly diagnosed throughout these treatment records. We can see chronic bronchitis, again, chronic bronchitis, clearly diagnosed throughout these treatment records. We can see a history of asthma that's worsening, clearly throughout these treatment records. And he specifically stated these continue to progress over time.
So from 1998 forward and not an acute onset.
Exactly, Your Honor. And if Your Honor were the trier of fact, which this court was not the trier of fact, but let's for a moment step into the shoes of the fact finder. If you have a physician who spent 15 pages of single-spaced medical report discussing chronologically, I mean, it's pretty incredible, Dr. Perper's report, chronologically, year by year, here is evidence of respiratory declining function within 8 or 9 different sets of treatment records, and then ultimately at the end, that doctor concludes he had declining chronic respiratory conditions that ultimately led to the deathbed arterial blood gas studies that
Whoa, whoa, whoa.
qualify.
Whoa.
I'm sorry?
What you just said at the end,
Yes.
I'm trying to make sure I understand. Is that what that trier of fact said?
Let me give you the site.
You talked about, when we were asking you to talk about Dr. Purper's report, you have cited to a bunch of stuff that talks about how he opined that he had chronic pulmonary disease.
Yes.
I don't think anyone's really here challenging that. But at the very end, you said something about how that produced the blood studies. And if that was in the report, I wanted to make sure you point me to the report. Or whether you're saying, if you have a bunch of evidence of a chronic, that he believed he had a chronic lung disease, that's enough for the trier of fact to conclude that. Which one are you saying? That he said it was produced, or evidence of chronic lung disease supports the conclusion that lung disease produced the test reports?
The latter, Your Honor, and I think that's a perfectly fair question. I appreciate what you said. That's a bit of I misspoke just a little bit there, but I don't think that matters, and here's why. Because the ALJ made that finding under 105D by Dr. Purper's medical report, which was relied on by what Dr. Purper said in the 47-page single-spaced report, and because that was a fair and rational inference for the ALJ to find from Dr. Purper's report, that's supported by substantial evidence.
Because at JA 615, which is Dr. Purper's report,
Yes,
he
Your Honor.
lists at the top there, the following evidence substantiates the worsening of the various respiratory parameters over the years of the chronic pulmonary disease survival. And one of those that substantiates that is the arterial blood gases.
Absolutely.
Followed a similar pattern of marked progressive worsening. So that is, I think, as close as, well, I think that is saying, and I think the ALJ and the board both thought that also was saying that was the result of his total disability.
Absolutely, Your Honor, and that's at 615, and that was listed here in my list, but you're exactly right. If you isolate that, there is your point in the record at 615.
Factually, I'm sorry, go ahead, counsel.
Your Honor, I was going to move on to the board, but I'd like to hear your question if you have another.
Factually here, I think I'm right, that the only arterial blood gas studies are the deathbed studies?
Correct.
Were there any in those years leading up to that?
There weren't, Your Honor, and of course, that's a point that Dr. Castle made. Dr. Castle, in his opinion, had stated, we have no baseline arterial blood gas studies to compare these two, and the ALJ didn't really afford a lot of weight to that.
That cuts both ways. I mean, he can
Right.
make that argument, but Judge Thacker just asked a question that if those are the only ones, those are the only ones he could be relying on.
Absolutely.
But he never, I mean, it is fair, isn't it, to say he never certainly explicitly makes the finding that 105 says needs to be made, right?
No, we don't have a physician here who went into the legal, realm and discussed,
Oh, come on. I mean, Purfer calls his opinions medical legal. It's not like he's in some laboratory with a white coat. He's I've done enough of these to know he knows his way around the black lung, claim system. That's really not the point.
It's not. But Judge Quattlebaum, I do think this is important. In fairness to Dr. Purper, I will say this is not something that comes up frequently.
Right.
And in fact, you'll notice with my friend on the other side, I mean, there's no legal citations to any kind of case law that deals with 105D.
So then how much, maybe talk about the standard of review, how much second guessing we should be doing of the ALJ and the board here?
You should do no guessing of the ALJ and the board, because this court's standard is whether it was rational, supported by substantial evidence, and in accordance with law. And the ALJ, you can tell this ALJ had a very detailed understanding of the law, because when this ALJ was tasked with considering modification in Judge Bartow's prior decision, he really went out of his way to outline the law. And then it was a,
Well, Ms. Prince says it's not in accordance with the law because the ALJ, they use the word link rather than produce.
well, as the Benefits Review Board pointed out, and I think this is a really great point that I think the board said when they were talking about the minority opinion in this case, and I think it answers that question. The Benefits Review Board specifically stated that that would ignore a salient fact. Dr. Perper was credited by the ALJ in this case, and he found that the acute respiratory injury at death was due to an underlying chronic worsening coal dust induced condition, and that's at 88. And so I think when you consider that, that eliminates any kind of a splitting of hairs between lingo. I know Ms. Prince mentions in her brief, she quotes the Webster's Dictionary and says there's a difference between this term and that. But when you think about what Dr. Perper actually did, he specifically, is opining in this case that his occupational exposures is what led to the declining disability and ultimately death in this case.
Isn't what Perfer's saying that, when you get to the actual language, some of his conclusions, not just what he's read, but,
Sure.
but the language, and particularly the language the board cites. It cites this quote, and I think the ALJ did, that the medical records document respiratory failure, complicating coal miners' pneumoconiosis with bilateral pneumonia and acute respiratory distress syndrome.
Right.
So I think he's clearly saying that he had pneumoconiosis, and that even though if he had some acute things at the end, they worsened, and that they were, they worsened the pneumoconiosis leading to his death. I don't think there's any difficulty drawing that from his opinion. The trouble I have is that the reg, and I grant you it seems likely that it doesn't come up much, because we're usually looking at does the overall medical opinion support it or not, that subsection 4 there at the end. And if we were in that boat, we'd have a lot, I think, more flexibility.
Sure.
The concern I have is the regs say you got to say something specific. And, I don't know, maybe you doubt that, maybe or there must be evidence that supports that. And, I don't know how to read it other than saying that you have to have a physician's report establish the results, not the death, but the blood studies were the result of one versus the other. And I don't know how you get that from this report, and I've read the 47 pages, and I only fell asleep twice doing it. I'm teasing. But the reference Judge Thacker talked to on 615 is the only place I could see that would allow you to even get close to satisfying that regulation. And maybe that's enough under a substantial evidence test, but everything else that the board cites to, I don't think does it at all. I think provides no substantial evidence. So I think this all hinges on that one statement on page 615, and you gotta take that into account where he has a specific heading. This just shows you, he's got some familiarity with the law. Did Mr. Mullins suffer from a total disability respiratory prior to his death? Total disability, that's the section that we're under, and, radio silence on these blood studies in that section. So maybe that's enough, but to me, that's a awful obscure reference to make what the regs seem to require as a specific finding.
Well, most of the rest of that section that you just cited has to do with his opinion, his reasoned medical opinion. And I know you said there's 4 ways. There's core pulmonale and qualifying PFTs and reasoned medical opinion was the one you were talking about in the
Right.
fourth category. And then we've got this other category of ABG. And clearly Dr. Perper in that section gives the reasoned medical opinion, and he cites this voluminous record, and he explains all this stuff. But just because something's not underneath a heading doesn't mean that the ALJ can't infer that. And I think I can't help but just go back to the fact that this is an incredibly well-reasoned, well-documented medical report where this doctor went in and explained just thousands of pages of data into a report, or at least hundreds of pages. I don't know if it's 2,000, but
Well, one of the things that I think the report said, the clinical and right lung necropsy finding documented the presence of clinical black lung disease, severe. Yeah, then in parentheses, I can't remember whether this was in the report or not, but it talks about severe macular coal workers, pneumococcus. He has dust-related fibrosis as well as legal black lung disease. He says that, doesn't he?
Yes, Judge Floyd, and I think the parties can generally agree that the presence of coal workers' pneumoconiosis in this case is not something that's contested. In fact, even employers' experts will at least acknowledge clinical coal workers' pneumoconiosis, which I think is mostly what you're referencing there. And to branch off of that, that was also a factor that Dr. Perper included in his ultimate conclusion regarding the deterioration of a chronic, impairment. I mean, he lists a
Right,
host
that was
of other
one of the
things.
many various respiratory parameters over the years of the chronic pulmonary disease from which he suffered,
Absolutely.
pneumoconiosis. So
Well, look
this
at-
doctor was
Go ahead.
perhaps over-inclusive.
I agree completely.
But
Judge
go
Sack.
ahead, Judge Floyd.
Look at page 628 of the joint appendix. I mean, this is just in my notes, and I can't remember whether it's in that report, but my notes seem to indicate that he has there's a note about, he was not a smoker, and all this stuff above, that resulted in total and permanent disability. Is that in the report, or is that just in my notes?
No, Judge, you're right. Another factor that he considered, I think more towards.
Yeah, that is at JA 628, number 2 listed there. Go ahead.
Judge Floyd, I was just going to say, I think that's another point that Dr. Perper was making, that non-smoking would eliminate another potential etiology in the overall conclusion with regard to chronic obstructive pulmonary disease. And he stated that, it was 27.92 years of confirmed coal mine dust was the major etiology there in the diagnosis of COPD. That's correct, Judge Floyd.
Can I ask you a question? I'm trying to, don't take this as anything other than just me trying to figure out the procedural setting that we're in.
Absolutely.
Let's assume we were to say that the modification opinion was wrong, and that the board's affirmation of that was wrong. What happens at that point? It seems like you'd go back, you'd have the original ALJ, and you'd be able to appeal that to the board? Is that what would happen?
Well, I think it would depend on how this court remanded
Yeah,
and the
yeah.
specific instructions. I know when I write a brief on remand, the very first thing I say is the court said this, and you need,
Sure,
you need
sure,
to make
of
sure you do
course.
that. But in this case, I think that would be pretty difficult because we already have Dr. Perper's medical opinion. We already have a fact finder who's completely reviewed that medical opinion. The findings are rational, supported by substantial evidence, and in accordance with the law, at least according
Yeah, but
to us. So I don't know.
I'm not, it sounds like you're trying to say, but we had a prior ALJ who said that I weighed his very, complete report with the other one, and I found one more persuasive. And you, I'm sure, disagree with that, but my only point is, if we were to say, look, he may have a very well-reasoned report overall on the linkage of pneumoconiosis to his death, but he didn't make this specific finding. And so in terms of a modification, that's improper. But you still could make whatever arguments you might have about the original ALJ's finding. I mean, again, you're right. How we were to write such opinion would determine what you could do. But presumably, you hadn't appealed the original ALJ's decision. You'd still have those appellate rights, wouldn't you? Or would you not?
Would we still have, Judge Thacker, may I ask it? I know I'm
Yeah,
over
go
time.
ahead.
Your question is, would we still have the right to appeal from the original Judge Bartow decision which denied benefits?
Uh-huh.
I think you would, because you have, the modification is based on Judge Clark's finding that Judge Bartow committed a mistake in a
Right.
determination of fact, and that mistake was specifically the way in which he considered Dr. Perper's report as it pertained
To subsection 2.
to 105D. Yeah,
Yeah, but the 105D,
Subsection
but
2.
the blood study subsection of that.
absolutely.
Okay.
So, to answer your question, I think we could do that, but I don't think we should do that.
No, I understand. I'm not
Because
surprised that's your
this is
view.
what fact finders do. I mean, this court may have looked at this case differently. This court may have considered all this evidence and reached a contrary decision, but we've got an incredibly reasoned medical report. It's well-reasoned, well-documented, and we've got a very well-articulated administrative law judge opinion. And this court's standard is, can we tell what the judge did and why the judge did it? And I think it's clear that in this case you can. And for that reason, I'd ask you to affirm the decision and order awarding benefits on modification from Judge Clark, and also to affirm the decision from the Benefits Review Board, which affirmed that decision. Thank
All
you,
right,
Your Honors.
Thank you. Hear again from Ms. Prince.
Ms. Prince, would you look at your JA 47?
647 or just
47.
47?
In your briefing, it seems to me, and Judge Thacker asked you this a while ago, that in your briefing, the board, your discussion of the latest ALJ opinion is largely limited to that one paragraph, JA 47. The one paragraph argues that Dr. Pepper's report is not the kind of report that reg requires, but you don't mention the need to make a separate finding that Dr. Pepper's overall report was well-reasoned or well-documented. And you didn't mention the ALJ's failure to consider other evidence or anything about the APA. I mean, is that, when she asked you, did you raise all this stuff before the board? Did you really do that?
Your Honor, we might not have raised it specifically under the challenging under 105D, but we did raise that specifically under challenging whether Dr. Perper's report in and of itself was well-reasoned or well-documented.
Well, I mean, the reason I asked that, I mean, maybe you waived it.
Your Honor, employer would argue that employer has consistently argued that Dr. Perper's report is insufficient. Under the Riley versus Island Creek Coal Company case, and that's 688 Federal Appendix 219, specifically around the 220-page mark, that we aren't required to make like specific arguments, that we are required to make general assertions like to the board, we don't agree with Dr. Perper's opinion, but we are allowed to expound upon that argument for reasons why we don't agree with Dr.
Well,
Perper's opinion.
let me ask you this question. Suppose we agree with you. What's going to happen? Is it going to get remanded?
Your Honor, if you agreed with our position, the case would be remanded to the board, and the board, we would request to remand back to the ALJ clerk to adequately apply the regulation.
So what do you gain out of this? What do you gain by if we remanded?
Your Honor, if you remand and the ALJ is required to properly apply the regulation as it's written employer's position would be that Dr. Perper's report is insufficient and benefits would ultimately be denied because the claimant would be unable to prove total disability.
With all
If-
with all the things you said, you don't think they could dress that up in a tuxedo and make it work?
They could, Your Honor, but that would be required for the ALJ and the board to properly apply the regulation.
All right.
And that's what, at JA 47 that Judge Floyd pointed out, that, what you argue is that Dr. Pepper's opinion, he improperly satisfied the requirements of the regulation. Is there somewhere in here where you talk about it not being well-reasoned or well-documented before the board?
1 second, Your Honor.
JA 47.
Your Honor, I don't have the copy of our board brief with me.
I'm just wondering, because a couple of times in response to Judge Floyd's question, you said that you had specifically argued that it was not well-reasoned or well-documented. So I thought you would be able to point me to somewhere where you did specifically argue that.
I don't have that JA citation right now, Your Honor, I'm sorry.
And if the widow passes away do benefits cease? Or do they go to somebody else?
No, Your Honor, once the widow passes away, there would be no further benefits in this case. I don't believe she has any dependent children, or it's not in the record that she has any dependent disabled children.
I may be confused on the waiver issue, so help me here. So as I'm looking at page 4.7, it says ALJ Clark improperly used Dr. Perper's opinion to satisfy the requirements of 718.105D. And you gave some of the reasons we just talked about here. As I understand your position, you're saying the regulations indicate that total disability can be shown 4 ways. I won't get them in order, but two of them don't apply here, and 2 that potentially apply are the blood gas studies and the overall opinion about whether that it's supported by well-reasoned medical opinions or something like that, right?
Yes, Your Honor.
Okay, I make, your argument about 105D and the blood studies, it seems to me you definitely preserve, that's what you're arguing here, right?
That is correct,
That one
Your
is.
Honor.
Okay, so the issue, there's this other argument about whether you challenge the well-reasoned opinion of Dr. Perper. But was that the basis of the misstatement of fact? I thought the misstatement of fact was only about the blood gas studies.
Your Honor, it is specifically only about the terminal blood gas studies.
And you know, the first ALJ weighed, maybe I can't remember all this, I may be getting, but so, and did the second ALJ, this is literally a question, so did the second ALJ say Perper's report satisfies 105D, number 1, and it also satisfies subsection 4 about a well-reasoned medical opinion, comparing that to all the other medical opinions?
Judge Clark did not do that, no, Your Honor.
So we don't have any opinion that looks at the overall well-reasoned opinions and says, looking at subsection 4, they are Perper wins. Or I go with Perper.
No, Your Honor, we do not have that. And if I may make one closing statement, Your Honors. I would specifically like to refer back to that JA citation that you all were discussing with counsel. It's JA 615. This is the only place in Dr. Perper's report where he specifically noted those arterial blood gas studies. And I would like to draw your attention to the whole statement there. And that second part of the statement was, during the terminal 2014 hospitalization when Mr. Mullins had contracted pneumonia and respiratory distress syndrome. That is the only time he mentions those arterial blood gas studies. So employer would assert that, you know, the words of the statute has meaning, produce and establish. That's the only time he mentions it. So employer would assert that he failed to meet that standard that was put forth in the regulation.
Whoa. So you're saying because right there he didn't add the words at the time, basically deathbed qualifier?
No, I was only pointing out that this is the only place that he mentions them at all.
Right.
So, and even there, he's talking about these acute illnesses of which the minor had attained during that terminal hospitalization. So even mentioning the ABGs, he's still referring to that terminal hospitalization and that acute pneumonia and acute respiratory distress syndrome.
Well, no, I don't, I'm not sure that's right. Yeah, the sentence begins with the following evidence substantiates the worsening of the respiratory parameters over the years of the chronic pulmonary disease survival. Then it's got 6 bullet points, and one of them is the arterial blood gases followed a similar pattern of marked progressive worsening form. And all we have are arterial blood gas studies from the time of his terminal stay. So, I mean, I think an argument could be, the best argument that he has is that this is an indication that he thinks the blood studies substantiate the worsening of the various respiratory parameters. And if the blood studies substantiate that, isn't that maybe not using the exact same language produced, but is it reasonable for the ALJ to say they produced them?
No, Your Honor, we would assert that that's not the case. A minor can have a chronic respiratory condition that causes a minor decrease in arterial blood gas studies, but those values may not be disabling in some cases. But when a minor goes in and the only blood gas studies we have is this acute hospitalization due to these acute illnesses, we have to have that physician's report to establish that those specific values, that disabling value, was due to that chronic pulmonary condition. Thank you.
All right, thank you. And Judge Quattlebaum and I will come down and greet counsel, and then if counsel would come up and greet Judge Floyd, then we'll go to our next case. All right, we're ready to proceed to our last case of the day. So, Mr. Adams, whenever you're ready. Okay.
May it please the court. I am Brent Adams, the Harnett County, North Carolina Bar, here on behalf of the defendants, Dr. Ibrahim Odie and his wife, Teresa. This is a case that arose from a civil lawsuit by the government against Dr. and Mrs. Odie, alleging violations of the False Claims Act. After some period of discovery and litigation, the case was settled with the Odies not, the settlement specifically stated there was no admission of liability. However, the Odies did surrender some $3 million or so of real estate and liquid assets. This agreement was reached on April the 20th, 2020. And as an additional provision of this settlement agreement, the Odies agreed to, or Dr. Odies agreed to sign a conditional consent judgment in the amount of $5,500,000. The specific terms of the agreement was that the judgment would not be recorded of public record, but would be held unless and until the U.S. Attorney had reasonable grounds to believe that either the defendants, either one of them, either failed to disclose their assets or made material false representations with respect to the settlement or the nature and extent of their assets. Now, this conditional judgment set in the U.S. Attorney's Office from April the 20th, 2020. It was a valid consent order, but it was not recorded pursuant to the agreement of the parties. Then on April the 11th, 2022, the United States Attorney caused the judgment to be recorded, and the Odys so the judgment was recorded against the Odys. Now, we did file a Rule 60 motion contesting the judgment. However, that was denied by the trial court in Odie 1. It was affirmed by this court just recently, and we.
So how is your argument different now than in that first appeal in which you already lost?
Well, we did make an allegation that the U.S. Attorney violated the agreement and that the judgment was invalid because the conditions preceding to its recording were not complied with.
Well, are those conditions preceded, were they in writing?
Yes, they were.
Okay.
Yes,
Where is that in the record?
I cited in my brief, I can't readily recall, but it was in writing, and it was approved by the court. Those proceedings, it specifically said that the conditions were that the U.S. Attorney must have reasonable basis to believe that the information was, that the assets were not fully disclosed, or that either party misrepresented the facts about the settlement or the assets. So,
But counsel, if you're, assume you're right, that you adequately disclosed those things and it was wrong for the government to file the notice. You challenged that in the first case, and I think the settlement agreement or the stipulation or something, says you would have been required to because the court was retaining jurisdiction over compliance with the agreement. So why do you get to do it again in a second case when you've done it first time and the agreement was that the jurisdiction was retained in the prior case?
well, the reason, if Your Honor please, is that the proceed with the lack of due process, the inability to call witnesses, the inability to have discovery.
But the court, you raised that too, and the court, you asked for discovery, and the court ruled on it, and you appealed, and we affirmed that. So, all that could be wrong, and I know it's unsatisfying, but it seems like that was part of what you raised.
Well, I believe, yes, Your Honor, that's true. However, the issue now is in OD2, the trial court ruled that there was res judicata. And basically, the court's order itself shows on page 7, the trial court specifically said that the United States relies on OD1 for its preclusive effect. So, and then it says that first OD1 produced a final judgment on the merits. And then 2, that the second, neither party disputes that OD1 concerns the same cause of action. We would say, if Your Honor pleases, that the denial of the Rule 60 motion is not a final judgment. The final judgment here was the judgment that was entered by consent of the parties on April 20th, 2020.
So you think if you make a motion, you got a final judgment, yeah, and then you make a motion to amend that judgment that's denied, that doesn't create claim preclusion?
It does not, it's not a preclusive, it's not a final judgment that can support does not have a preclusive effect because it's not a final judgment. The judgment itself stands. And as a matter of fact, the entry of the judgment itself is one of the one of the evidentiary facts we have to show in order to support our claim for relief. Now, before this judgment was
What are you
entered,
arguing before us that you did not argue in OD1?
well,
Anything?
we did argue some of the things we're arguing here. However, that
All of the things you're arguing here.
and the effect of that,
I mean, if there's something that you're arguing here that is different than what you argued in OD1, that's what I'd like to know. You said some of the things, and I think it may have been all of the things. But if I'm wrong, if there's something you're arguing in front of us now that you didn't argue in OD1, now would be a good time to tell us.
well, I believe you're right, Jonna. We did make all of those arguments.
Okay, so
However-
then your only argument is, or what's your basis as to why that's not claim preclusion is because, in your view, Rule 60 motion does not lead to a final judgment. Is that
That's correct. We continue, Your Honor, that the preclusive of the denial of the Rule 60 motion was simply an affirmation of the rule of the original consent order. And we can see the consent order was valid, but that's different. The difference is, Judge, that we made no counterclaim in our Rule 60 motion. It was an attack on the judgment which was denied, so the judgment stands. And so here.
So what if, so your point is not any sort of, this is a different, you're doing something here. You're just saying technically, to apply res judicata, you gotta have a final judgment.
A final judgment.
And a Rule 60 motion doesn't count for one.
It does not count as a preclusive
Do
effect.
you have a case that supports that? Or is that just kind of not common sense, but just naturally by the very nature of that type of rule?
I do not have a case on that. And Judge,
I think you're conflating claim preclusion and issue preclusion in this. I think you're conflating the two. Issue preclusion applies when the case is actually litigated. Claim preclusion only requires a valid and final judgment. We have a valid and final judgment here, don't we?
we have a valid final judgment that even if we were to win on our counterclaim, the judgment would still be valid. It'll still be sitting in the U.S. Attorney's Office to be recorded in the event that they one day would find that the defendants have violated that order. But
this case is about claim preclusion, not issue preclusion, isn't it?
well, I think either one, it has to be based upon a final judgment.
No, I don't, well, I mean, I think the distinction is one is actually litigated. In this case, it wasn't litigated, it was settled.
Well, but our counterclaim did not exist until April the 11th, 2022, when the U.S. Attorney caused the judgment to be recorded.
Right.
We had no claim when OD1 was argued. We had no claim. The claim did not exist. And I'm sorry, when OD1 was decided, we had not made the claim. No claim was made.
In fact, your position is you reserved it. In the agreement was that you would be able to assert failure to comply with it.
Yes.
right?
Yes.
But what about the fact that, does it matter? I don't know if this is a res judicata fact or a practical fact, but if the district court retains jurisdiction to handle any disputes about compliance with the settlement agreement, does that matter at all? I mean, it seems to me, you know, I used to appear in front of Judge Floyd a lot when he was a district court judge, and if we had a settlement agreement and he retained jurisdiction over the settlement agreement, and I brought a new case, he might not like that, and he might have a good reason not to like that. Now, here it went to the same court, so maybe no harm, no foul there, but do you even get to bring another case when the court retains jurisdiction of that?
Yes, Your Honor, in this case, and here's why. In this case, the judge specifically ordered that that this was entered without prejudice to the defendant's right to bring an additional action for breach of contract because of the alleging that the U.S. attorney violated the terms of the consent order and violated the terms of the settlement. That's why we could bring a separate action, and that's why we did not bring the separate action until.
And it was responsive, right? It was a counterclaim.
Yes, our separate action was the counterclaim. And no cause of action, we did not have a cause of action until April 11th, 2022 for breach of contract.
All right, you have some time in rebuttal, Mr. Adams. Thank you.
Thank you, Your Honor.
My name is Neil Fowler, Your Honor. Your Honors, I represent the interest of the United States in this matter. As the court has focused, the primary issue in this case is res judicata. I'll address the other issues as the court directs. Obviously, res judicata applies. This is claim preclusion. I'll start with Judge Floyd's question, if I may. There were 3 documents. There's a settlement agreement, which is at JA 118. There's a consent order that implemented that, which is at JA 115. And because of the complications of writs of garnishment and writs that applied, there's a 3rd order implementing, which is at JA 406. Those are the 3 documents that are issued here. 2 of them refer specifically to the United States seeking to enter the consent judgment if certain conditions were met. We had to reasonably determine that they violated the specifics of that consent order in the settlement agreement. And they did, in fact, violate those agreements. They had to provide financial statements that were complete, accurate, and current, and they clearly did not. There was evidence presented to the judge on that.
I don't mean to cut you off
Oh,
on
no,
that,
absolutely.
but I think, I may be wrong, at least from my standpoint, this comes more down to the question of whether the litigation in the Rule 60B context is enough to satisfy the final judgment requirement of claim preclusion.
Yes, Your Honor.
And, there's an interesting debate about, what they reserved and what you reserved, and did one kind of gut the other? That's kind of interesting to me. But for sure, the district court considered all the arguments that, that your colleague is making now. He's essentially conceded that. And so the question, it seems to me, is whether doing that in the context of a Rule 60 motion, satisfies the final judgment. It comes after the judgment. Kind of instinctively to me, it would be incorporated retroactively into it, but I may be wrong on that. I don't have any authority for it. Do you got any authority on that point?
We do not have authority. This is such a unique situation, Your Honor. I don't believe there is such authority, but we agree with you completely. The consent judgment that was affirmed in the court's order on the motion to set aside is the final judgment. The consent judgment, they actually agreed was a final judgment. That was part of the consent order. They specifically agreed that that would be a final order if entered, and in fact was the final order entered. The motion to set aside that the court considered and ruled on, he did hear evidence. That was a question that the court had. He heard, they presented evidence in affidavit. We presented affidavit. They had other documents they attached, including the financial statements. So all of that was considered when he ruled on this issue of whether we violated the settlement agreement. Judge Dever found that we did not. So that, to answer your question, Your Honor, that goes back to the finality of the consent judgment that was entered. It was conditional initially, but because it was triggered specifically by the consent order and the settlement agreement, it became the final judgment, Your Honor.
And he contested that, the entry of that consent order, it said that it should be set aside.
Correct.
In his Rule 60B motion.
Absolutely.
Considered by the court and denied.
Correct.
And now he's trying to file a counterclaim.
Correct. There was a narrow exception both in the settlement agreement that I referred to and the consent order that allowed them to only challenge whether or not we violated the settlement agreement by not reasonably determining that the financial statements were not complete, accurate, and current.
So you don't have any quarrel that that's a right he has a right to assert?
They carved that out, Your Honor. We
And-
agreed to that.
And
Yes,
if
Your
you
Honor.
started arguing why you rightfully filed it, he had a right to challenge that.
That narrow issue. But he specifically waived any kind of due process arguments, any right to jury trial, any other rights were specifically waived in those documents, Your Honor. The consent order specifically. And that's cited too in our brief. I can give that to you again if you would like.
No, it's, yeah.
And all that stuff you just said was either considered or reconsidered at the time the 60B motion was heard and denied.
Yes, Your Honor. And I would correct slightly, Judge Thacker's question was whether they raised any new issues in this OD2, as I call it. They actually raised less issues, Your Honor, because in OD1, they raised all these due process arguments, all these discovery issues. In the response to our motion to dismiss the counterclaim, they did not raise all these issues. We argued that they were waived because they did not raise them in OD2 in the proper context. So they did not only did not raise new issues, they raised less issues that have already been decided by this court in May, which we pointed out, Your Honors.
It would seem, neither one of you have a case on this, which is interesting, but it would seem, I mean, Rule 60 motions aren't like things that never happen, and courts have grounds in those, and OD appealed that, we affirmed it.
Mm-hmm.
It would just seem a pretty significant thing for us to say motions to amend the judgment aren't wrapped up into the final judgment in some way. I haven't I'm not articulating the exact way they do, but it seems to me built into the finality is the ability to make a chance to amend it. Right. And if you if you pursue that route, as happened here, you've pursued it in the judgment in the case that was entered, and the final judgment there is kind of what is the res judicata judgment.
We agree, Your Honor. We do not believe there is written authority specific on this point. It is a fairly unique situation. It may be helpful to have a written opinion guiding us on this, but our view
This
is...
seems like fairly unique litigation too, so.
Yeah, it was very, well, and hopefully we're coming close to the end at this point, Your Honor. But it's our view that that consent judgment that was entered by the court based upon what the settlement agreement and the consent order said is the final judgment. There was one avenue to challenge it, which they pursued, and they failed in that. And so it would relate back, as the court indicated earlier, to the consent judgment. And the orders and the settlement agreement make very clear that the only thing they can challenge is whether we violated the terms of the settlement agreement, and we did not. To answer another question, there was no evidence.
But you may have, the point is, I mean, I'm not saying you that, but even if you did, he brought that,
Right,
and there was a ruling on that.
There was evidence presented. The court actually pointed out that they did not present adequate evidence to meet the arguments that we made in the affidavit that we made and statements we made. And so the court ruled on it. We believe there should be finality there, Your Honor. You only get one shot, one bite at the apple, as you well know. Res judicata says that. You can't come back a second time. They could have brought it differently. Instead of a motion to set aside, they could have tried to bring it in that first case or as a separate action. They chose not to. Whatever avenue they choose, they only get one, and so they certainly shouldn't come back to the court today in OD2.
Well, I'm not sure he gave me he answered my question, but he did cite Arizona versus California, which stands for the proposition that issue preclusion attaches only when an issue is actually litigated and determined by valid and final judgment. And that's true, but in this case, it's not. This case is about claim preclusion.
Absolutely, Judge Floyd. This
So
is all claim.
Res judicata gets it.
Absolutely. This is claim preclusion. They specifically raised whether or not we violated the settlement agreement in OD1. They raised it again in OD2, the exact same issue, same claim. Let me be precise. They raised the same claim, same parties, and final judgment, which they agreed was the final judgment. So they meet all three requirements of res judicata, Your Honor, for claim preclusion, which is what this is. There was some confusion, but this is definitely claim preclusion. If there are no other questions, let me wrap up. We think this is clear. The litigation, OD2 was to collect on the judgment that was entered properly, and we believe the court should affirm and avoid the waste of further judicial resources so we can collect on this judgment against Dr. Odie. Thank you very much for your attention.
All right, thank you.
May it please the court. In answer to, I believe, Judge Floyd's question about did they have a right to file to file a separate claim. And on Joint Appendix 141, we quoted the trial judge from the consent order, court's stipulation of dismissal in court order provides that, quote, but the defendants are not waiving defenses to collection efforts, nor are the defendants waiving the ability to initiate an action alleging that they are entitled to relief because the plaintiffs have violated the settlement agreement by filing the notice. So I think the important part is, and then the condition of the consent judgment was that the governments must reasonably determine that one or both of the individual defendants failed to disclose assets and income in sworn financial statements provided to the government in this action or made material misrepresentations to the governments regarding settlement or assets to in this case. So, and that's found on Joint Appendix, page 121. So, and further answer to response to Judge Thacker's question about, well, did you allege the same thing? We would contend, if the court pleases, that this is a different claim. This is a counterclaim against the government, a civil counterclaim against the government for breach of contract. That did not exist in OD1. What existed in OD1 was our attempt to have the judge to nullify the effect of the judgment insofar as the assets of Dr. and Mrs. Odie, as far as the judgment against them. That consent judgment, which we rely upon, without the consent judgment, one of our essential elements of our consent judgment is the consent of our counterclaim is the consent judgment itself. That our counterclaim did not arise until April 11th, 2024, when the U.S. attorney caused the judgment to be recorded. That is when our claim became in effect. That is when our claim arose. It did not arise in OD1. That's the difference. And the cases clearly say that for an issue preclusion to allow, whether issue preclusion or claim preclusion, there must be a final judgment. Now, it's clear that Judge Dever, when he ruled that dismissed our case based upon res judicata, was relying on the consent judgment. It said this court ordered the United States relies upon OD1 for its preclusive effect. And our cause of action, the complaint, the counterclaim did not arise until in 2024, when the U.S. Attorney caused the judgment to be recorded. And the judgment would be effective as a consent judgment consistent with the agreement of the parties, even after, if we were allowed to pursue our counterclaim and win, the judgment is still there, but it would not be recorded. It would be stricken from the record. Is what our request would be, but it would still be there for the U.S. Attorney. It would still be effective. So we don't contend now that the judgment was an invalid judgment. Certainly it was, because our clients, Dr. Mizzotti, agreed to it. So there's so that's a different issue than existed during OD1. Although we admit that in OD1 we did allege that the defendant violated the consent, that the plaintiff violated the consent agreement. Also, there it's apparent from both OD1 and OD2 that we were not afforded any due process of rights. We were not allowed to introduce evidence. We were not allowed to call witnesses. We were not allowed to do discovery. And for that reason alone, the order dismissing our counterclaim should be reversed, and we should be allowed to proceed to trial on the merits of our claim.
Well, let me ask one final, I hate to drag. Is your argument that what they violated is your clients did not ever want that judgment recorded? Is that what you're saying?
Yes, that was the
How in the world would they ever enforce the judgment if they can't get it recorded?
Well, they were not allowed to enforce. Well, Dr. Mizzotti gave up some $3 million worth of assets. That was what the government got. Plus, they said as a final kicker, and I wasn't involved in that part of the litigation, but as a final kicker, the government said, okay, well, we agree this, but we also want you to sign this conditional consent judgment for $5.5 million. We're not going to record it so long as you told us the truth about everything. So long as you've provided all of your assets, we won't record it. It would just be like it didn't happen, but we've got it in case we find out that. And our contention is that the U.S. Attorney had no reasonable basis to make a determination that either they didn't include all of their assets in the financial statements, or that they misrepresented somehow. That's our position. Thank you very much.
All right, thank you. Judge Quattlebaum and I will come down and greet counsel, and then if counsel will come up and greet Judge Floyd, and we'll adjourn court for the day.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.
Thank you. It's not yours. There you go.
Got our pencils too?
Yeah.
all one case? No. Oh, we gotta rubber band these. I wonder if we'll just do that when we get back to the chambers.
I think we might have to rubber band some of these so they don't fall apart on the way over.
I think I've got all of that.
I think all of Robin's great.
You're like, I literally was, like, staring
The plaintiffs.
like, I promise you was there.
Yeah, will you just rubber band? Well, this is all schmuck.
I've got binders.
Who has the day? Okay, great. I'll take the binder. Thank you.
Hi. Oh, yes. He took them.
He did take the.
Yeah, I think so. He had a pencil and pen. Yeah, I think he's got them.
Did Judge Floyd leave anything here?
I
He's
didn't-
looking for a court sheet that he wrote some notes on, but
I don't see it. I
anything.
can check with his clerks and see if they.
If they.
Yeah, if they grabbed, they might have grabbed it. So let me
Yeah.
go check with them.
Okay, thank you.
Yeah.